Good afternoon, everyone. Thank you for joining us today for a Beverly Hills Bar Association MCLE webinar. Today, we are going to talk about Romag and trademark damages. Today, as I said, we are going to talk about how the Supreme Court alters trademark landscape. We're going to discuss the damages issues post-Romag. Today with you are members of the Executive Committee of the Beverly Hills Bar Association IP, Internet, and New Media section. I'm Leslie Schaefer. I'm a managing director at Econ One Research, where I work as an economic expert and I measure damages. Also with me are Jonah Grossbart and Ryan Hatch, and I would like them to introduce themselves. Jonah, why don't you go ahead?
Hi, my name's Jonah Grossbart, and I'm an attorney with SRIP Law. We do mainly IP litigation.
Hi, everybody. My name is Ryan Hatch. I'm an attorney at my own practice, Hatch Law, and I also focus mainly on IP litigation. I also do a bit of civil litigation. I've been practicing for about 15 years, most of that in the big firm environment.
And as I said, I work as a damages expert, but also I am the vice chair for our section. And a shameless plug, we'd love it if you would join us. We have monthly meetings. Right now, of course, they're on telephone or webinar, and otherwise, in regular times, we meet once a month over at the Beverly Hills Bar Association. We talk about a lot of really great IP issues, and we'd love to have you. All right, time for our show. What are we going to talk about today? Well, first of all, we're going to start by talking about the legal theory related to trademark infringement remedies. Then we're going to talk about how experts like myself estimate damages. And then we're going to get to the really interesting parts here about Romag versus Fossil. What was this case all about? Why does it matter? And what are the implications of this Supreme Court decision about willfulness? Finally, we're going to leave some time at the end for Q&A. So as I said, please make sure if you have questions, enter them in the Q&A box or even in the chat. So I'm going to turn it over to Jonah, and we look forward to talking with you.
Hi, everyone. I'm Jonah, and I'm going to start talking about trademark infringement remedy. So under the Lanham Act, federal trademark law protects against numerous trademark-related violations. Trademark infringement, trade dress infringement, false advertising, trademark dilution, counterfeiting, and cyber piracy / cyber squatting are what it mainly deals with. 15 U.S.C. subchapter 3 has the general provisions that articulates the available remedies under the Trademark Act, under the Lanham Act. Most trademark plaintiffs seek injunctive relief under section 1116. Some also seek monetary relief under 1117. We're going to focus more on monetary relief today because that's where this decision, that's what this decision was discussing. The goal of section 1117 is to achieve equity between or among parties. A defendant may not retain the fruits, if any, of unauthorized trademark use or continue that use. And the plaintiff is not, on the other hand, entitled to a windfall. And that's always something that comes up a lot in the trademark litigation monetary relief issues. Under section 1117A, a trademark holder that has proved infringement may recover damages in 3 ways. They can get the defendant's profits, any damages sustained by the plaintiff, and the cost of the action, which includes attorney's fees if it's an exceptional case. Recovery of the defendant's profits is a remedy that is equitable in nature. It is not based on the injury or damage sustained by the trademark owner, but rather it is based on the infringer's unjust enrichment or the need for deterrence. Recovery of the damages sustained by the plaintiff, actual damages, is a remedy intended to compensate the plaintiff for any actual injury that resulted from the infringement. The court may award the plaintiff a sum reflecting the damages that plaintiff sustained, or it has the discretion to award up to 3 times the actual damages. And that brings
Ryan,
us
you
to
want to take it
Romag
away?
versus Fassler. Sorry for speaking over you.
Yep. So as Jonah said, there are different forms of relief in trademark cases. One form is injunctive relief, which is important to stop the infringing action. The second form, which we're focusing on here, is damages, and that can be important if the trademark infringement has caused harm, financial harm, to the plaintiff. We're going to be talking about a case called Romag Fasteners versus Fossil. This case began in Connecticut District Court, and it worked its way up through the federal circuit and then to the Supreme Court, where this month the Supreme Court issued an opinion. The opinion did alter, as the title of this presentation says, it altered the landscape for trademark damages by changing the rule that governs how a plaintiff can get profits. And this refers to the defendant's profits that were related to the infringement. The question presented at the Supreme Court was a pretty narrow one. It related to whether willful infringement is a prerequisite for an award of an infringer's profits for a violation of a specific section of the statute, and that section involved trademark infringement as distinct from other theories such as trademark dilution. It's narrow in the sense that the court was asked to decide whether if a plaintiff does not show willful infringement, that absolutely precludes recovery of the infringer's profits. The facts of the case are kind of interesting. You've probably all seen these magnetic type fasteners. The defendant was Fossil, which is a fashion company, and I learned from this case that they also manufacture products for a number of brands. And you're probably familiar with Fossil. You're probably also familiar with Puma, Emporio Armani, Michael Kors, DKNY, Kate Spade, Tory Burch, Armani Exchange. I wasn't aware of this, but Fossil is a contract manufacturer for all of those brands. In other words, those brands do not themselves arrange for the manufacturing. They license their trademarks to Fossil, and then Fossil slaps those trademarks on a product and it's sold to the end consumer. So this case has implications, I think, across the industry. It's not just about Fossil's actions, as you'll see, it's about the actions of their contract manufacturers in other countries. These magnetic fasteners work by closing the bag with magnetism. It was an invention that's patented by the plaintiff. He started a company called Romag. He filed his patents and trademark applications and got those protected by IP. Romag had a license agreement with Fossil, or actually an agreement with Fossil, that Fossil would be using the Romag fasteners in their products. And Fossil had those products manufactured in China, and unbeknownst to Fossil, so they say, their manufacturer was using counterfeit Romag fasteners. And those fasteners even had the name Romag on them. So the lawsuit ensued, in which Romag sued Fossil for trademark infringement. They also asserted claims for patent infringement, etc. Next slide. It's interesting that the contract manufacturer is located in Hong Kong. This is the party that Fossil had contracted to, and this company was called Superior Leather. Superior Leather was responsible for the manufacturing of the bags in China. And I went to their website, and they are pretty proud of themselves as offering the highest standards in quality service, and boast that they Their customers include trendy retailers, leather specialty stores, career women's specialty stores, prominent designers, and well-known chain and department stores. So they do a lot of work, not just for Fossil, but they cut corners in this case by using a counterfeit Romag fastener rather than the authentic thing. And the authentic thing was being manufactured by Romag's own people over in China. And they noticed that there was an issue when they stopped receiving orders for the Romag fasteners. They complied with their contracts for a little while and then decided, nobody will know the difference if we use the fake ones because they still say Romag and they're magnets, so it's all good. Next slide. The district court, the jury entered a decision in favor of Romag and concluded that Fossil's infringement was not willful. And this is the important part of the case because under the law at the time, if you don't have willful infringement, then you don't get the defendant's profits. Nonetheless, Romag did offer evidence of those profits, and those profits, the district court jury found, were about 6.7 million. More accurately, that was the amount of damages that the jury awarded, and part of that damage was based on a punishment that they felt Fossil deserved for not policing their manufacturing and allowing this to happen. The case went up on appeal to the Federal Circuit. Connecticut, of course, is in the Second Circuit, so the Federal Circuit applied Second Circuit case law and affirmed. I'm sorry, I skipped something. The district court then struck the damages award on the basis that willfulness is required in the Second Circuit, and that had not been shown. And then the Second Circuit affirmed, essentially just applying the Federal Circuit affirmed, essentially applying Second Circuit law and not really feeling that they have the ability to deviate from that. So here's the jury verdict. You can see question number 3, which I had these backwards, but question number 3 is whether Romag has proved by a preponderance of the evidence that defendant's trademark infringement was willful. And the jury said no. And the reason was that Fossil was not directly controlling what was going on in China and Hong Kong with its supplier, with Superior, and what was happening. So they didn't on purpose decide to switch out the Romag fasteners with fake ones. The jury awarded the 6.7, and that was increased a little bit for some actual damages. But most of this, you can see from the question, was to deter future trademark infringement. So the jury decided that it was necessary to kind of punish Fossil, and so that this would not happen again, to the tune of 6.7 million. Both parties appealed. You can go ahead to the next slide. Both parties appealed to the Federal Circuit, and of course that was affirmed, and then Romag appealed to the Supreme Court. And the Supreme Court looked at the question, a very narrow question, as to whether willful infringement is a prerequisite, and said no, it's not, because this is my favorite line from this opinion. The court usually, nor does this court usually read into statutes words that aren't there. So if you know anything about law, you know that it happens all the time. The court's reading, not necessarily reading into the statute, but finding law that's not in the words of the statute. So if you are arguing a decision or have an issue in your case, or come across an issue where you can make this kind of argument, maybe do it, because Justice Gorsuch, who authored this opinion, is open to this idea that if a law or a judicially created law is not reflected in the statute, it should not be there. Concurring opinions were filed by Justice Alito and Justice Breyer and Justice Kagan. There was no dissent.
All right, Jonah, you want to bring us back to damages?
Sure, and I'd like to kind of jump off on what Ryan was saying, because my firm, we were involved in a copyright case, the Fourth Estate case, and that went up to the Supreme Court last year. And that was a statutory interpretation case about the Copyright Act. And they read the law as what the law says. And so, a lot of times you'll see things that isn't necessarily in the law. And, if it's not, I think, as a litigator, you should be making that argument, going all the way up if you have to, because it seems like they're very receptive to that. At least in these two cases. Back to the plaintiff's actual damages. Most circuits require evidence of actual confusion or intentional deception to grant recovery of a plaintiff's actual damages. And a case that discusses that more in detail is the International Star Class Yacht Racing Association case that we cite here. It says, plaintiff unable to demonstrate actual confusion or pecuniary loss, they're going to have problems, but this does not preclude a recovery of the defendant's profits. Sometimes surrogate evidence is acceptable in lieu of a showing of actual confusion, and we have another case, Southland Sod Farms versus Stover Seed, that discusses that. The proof sufficient to establish actual injury may include the results of consumer surveys, direct testimony, and market analysis. And a lot of times in trademark cases, it's really important to have consumer surveys and all that to get your damages. Next, we're going to move on to costs and attorney's fees in trademark actions. A prevailing party is entitled to recover the costs of the actions. Attorney's fees may be awarded to a prevailing plaintiff or defendant. In exceptional cases, the court may award reasonable attorney's fees to the prevailing party. This was up in the Supreme Court in 2014 in Octane Fitness versus Icon Health. The Supreme Court said that district court should evaluate the totality of the circumstances when determining if a case is exceptional, such that attorney's fees should be awarded, and an award of attorney's fees can be justified even if the losing party's conduct does not rise to the level of bad faith conduct. Then the Ninth Circuit adopted that in a decision in 2016. We have here the Sun Earth case. An exceptional case is simply one that stands out from the others with respect to the substantive strength of a party's litigating position, considering both the governing law and the facts of the case, or the unreasonable manner in which the case was litigated. Additionally, the burden of proof was changed from clear and convincing evidence to a preponderance of the evidence, and that's the Ninth Circuit adopting Octane. Then you have defendant's profit, history of willfulness. Prior to Romag, circuits were split as to whether willfulness is required for an award of the defendant's profit. The Ninth Circuit, willfulness was required, but it wasn't that clear. There's cases that have held, like Lindy Penn, the Ninth Circuit instituted a willful standard on plaintiff to obtain an accounting of profits. In the Ninth Circuit, willfulness is required to disgorge an infringer of its ill-gotten profits. That's Spin Master. But in the Ninth Circuit jury instructions, it says willfulness is a prerequisite, but if you keep reading, it can say an instruction that willful infringement is a prerequisite to an award of defendant's profits may be an error in some circumstances. So, we did we looked into this a little bit, and it seemed like most of the courts in the Ninth Circuit were holding that willfulness was required, but it looked like there was an out in the jury instructions. In other circuits, the First Circuit, willfulness was usually required. In the 10th Circuit, willfulness is required due to the punitive nature of the award. Third, fourth, and fifth, willfulness is not a prerequisite to an award of profits, but may be considered as a factor. In the 8th, they didn't directly address the issue, but it appears to follow the 1st, 9th, and 10th in requiring willfulness. In the 2nd, the district courts were split, but the majority of courts appeared to require willfulness for defendant's profits.
Which, of course, is what brought us to Romag in the first place. So now what we're going to talk about is how your expert actually estimates damages for you, and as a defendant, how your expert provides really important input into how damages are portrayed. Just a quick recap. Remember, under Section 1117A, a trademark holder who has proved infringement can recover damages three ways. We talked about so far all three: defendant's profit, so that would be disgorgement of defendant's profit, the actual damages of the plaintiff, and then the cost of the action. What I'm going to do now is explain methodologies for disgorgement of defendant's profits and plaintiff's actual damages within the context of these issues we're talking about today with Romag. So first, we're going to start with defendants. Disgorgement of defendant's profits has two parts. The first part is that the plaintiff must prove defendant's sale. And by that, what I mean is gross sales. It's just what is the revenue of the products that are infringing. It is then the obligation of the defendant to prove all elements of costs or deductions that they want to claim from those gross sales. And so to get to profits, you take the sales identified by the plaintiff, the costs identified by the defendants, and subtract the two to get to a profit number. This is very important because there's a lot of aspects of costs that need to be considered. For example, things that don't always get accounted for: payroll, benefits, employee training, a lot of expenses like travel, phone, entertainment, rentals, supplies. There's a lot of other aspects that you want to make sure that your expert considers, especially as a defendant, to make sure that they are accurately showing all of the costs that need to come out. It's interesting that before Romag, an award of defendant's profits was available even if there was not a finding of willfulness, if parties are direct competitors. The idea here is that if you're direct competitors and your competitor is infringing your trademark, they are benefiting by getting sales that you are losing as a plaintiff. And so the defendant's profits were seen as a proxy for the plaintiff's actual damages based on a theory of unjust enrichment. In that aspect, it was really important that the plaintiff's burden was to prove defendant's gross profits from infringing activity with reasonable certainty. And this comes from Lindy Penn from 1993. What's key here is, I'm going to give you an extreme example. Suppose that Romag said that the defendant's sales were all of the products that they sold in the damages period in their entirety. Well, as Ryan described, they sell a lot of products, and some of them have absolutely nothing to do with the trademark infringement. And so it's important to make sure that the actual sales are related to the infringing activity. There are different questions you may ask if you're a plaintiff's damages expert versus a defendant's damages expert. So as a plaintiff, first question here was, are parties direct competitors? Because it really matters in terms of setting up that proxy for the plaintiff's actual damages. Different ways you might make sure that your plaintiffs are doing their jobs. What you want to do is make sure that they're reviewing internal strategy documents, third-party market research, surveys to figure out what is the competitive landscape of the market that you're looking at. Another issue that's important is that they want to make sure, as I said before, that you're apportioning sales to carve out other influences besides the infringement. As a defendant's damages expert, you have other considerations. Most importantly, which products infringe. You want to make sure that the plaintiffs aren't including sales that should not be there. And that, of course, goes without saying in terms of direct competition, but also when they're not. The other really important point, which we brought up earlier, is to identify the costs associated with those sales. Because as you can see in the case law, there are instances where the defendant has had to pay total revenue as damages because the defendant did not deduct costs properly. Another way to think about this is to identify direct versus indirect costs. And what we mean by that is, are there elements of your business that vary with sales. So if you have higher sales, you have higher costs. And so you want to make sure those especially are identified, because those are the key elements you want to deduct from the revenues. The other thing to consider are both temporal and geographic factors. For example, what if the infringement has no visibility in certain places? You want to make sure that any sales in those locations are not included in the damages. Okay, so now we're going to turn to plaintiff's lost profit. The first thing to know is there are several ways to calculate plaintiff's actual damages. And right off the bat, what's important here with Romag and willfulness is that it's a lot more complicated to calculate plaintiff's lost profit. And so there's an incentive to think about looking at disgorgement of defendants' profits for just that reason. So the ways that you can do it are, first of all, actually calculating what amount of money did the plaintiff lose from sale. The next, which we're going to get into, is called price erosion, then reasonable royalty, and then finally corrective advertising. And we're going to touch on each one of those. Okay, so lost profits, as it sounds, are additional sales the plaintiff would have made if the infringement had not occurred, and then net any incremental costs the plaintiff has for those sales. It's key here that it's necessary as a plaintiff's expert to make a causal connection between the alleged violation and the actual damages, because you can't assume that the plaintiff lost the same volume of sales as were made by the defendant. You know, some key ways to look for that are to look at trends over time. You know, before the infringement versus after. Do you see a big shift in your sales? Are you suddenly seeing a huge drop, particularly in geographic areas where you know that infringement is recognized? Things to be looking at, besides sales, you're going to be watching your profit margin over time and your market share, as well as your marketing spend and other costs. If you're finding that you have to spend more on your marketing to counteract this infringement, that is a clear indication of the relationship between the two. Okay. All right. So if you're the plaintiff's expert, what kind of information are you looking at? Well, the most important thing to start with is you're going to need financial statements, and transactional data are helpful. These are the data that you're going to use to examine trends in sales, perhaps by product code or customer, to see if sales are increasing or decreasing prior to the alleged infringement. This is important because if you already had declining sales before infringement, and then you continue to have declining sales afterwards, if they're on the same trend, that shows that it's not necessarily the trademark infringement that is causing that decline, but your expert will be able to determine whether or not that's true. It's a good idea to ask questions. Are there any increases or decreases in your marketing expenditures or your advertising plans? Are these other reasons why you might be seeing a change in your sales? A few other things you'll look at: business strategy documents, forecasts, any competitive intelligence. Who do plaintiffs and defendants consider competitors? You know, it's very important, as we said, to look at who is in that market. Have you noticed in their own documents, are the plaintiffs concerned about other competitors besides the defendant? This is an area where you might be finding that there are reasons for changes in your sales that are not related to the infringement. And then, as we've talked about, our market share or other things changing over time, are there other things going on that aren't related to the defendant? Okay, so now my fun as an economist, I get to talk about economics a little bit. Price erosion is when the existence of infringing products leads to greater competition in the marketplace. The key here is that the plaintiff needs to show that it has to lower its own prices simply to maintain its market share. So it sees that it's losing sales, it lowers its prices so that it can continue to make those sales. This is a really key relationship to show between the infringement and a price decline. Third up, as we mentioned, is reasonable royalty. So here the question is, what do you do if the parties are not direct competitors and you're finding it very difficult to quantify lost profit? One thing that you can do is you can identify the amount that the parties would have agreed to if they had negotiated a license in advance. Now, this is not listed explicitly in the Lanham Act, but what you can see in the case law, as I've noted here, a reasonable royalty based on a hypothetical negotiation can be a measure of actual damages in a trademark infringement case. A few things to consider for reasonable royalty. One is, does the plaintiff have prior licenses or licensing policies? Those are going to be very key, especially, of course, if they are with the defendant, but even if they're not, it gives you a history of what license amount they were willing to accept in other relationships. In addition, that leads to past negotiations between the parties. There might be a lot of documentary evidence that they were trying to negotiate a license that would provide you with important information. And then third, what are the norms in this industry where you are? Is there a royalty rate that you see come up over and over and over again? That could be something very interesting to consider. The circuits really do have different interpretations about whether prior evidence of licensing is required for using reasonable royalty. And what I'm going to do is I'm going to turn it to Jonah for a moment to talk about his experience with this issue.
Yeah, thank you, Leslie. I had a case, it was a trademark case where it was, we represented the estate of Thelonious Monk against North Star Brewing, and it was a case up in the Northern District of California, and we had to deal with the reasonable royalty issue. And what we did is there were past negotiations, so we used some of that. Then we also used some industry norms. We were able to look at what other licensing deals in the beverage space, alcoholic beverage space was, because it was a case about beer. And through that, we were able to try to calculate royalties and come up with different damages. I was representing the plaintiff. Case ended up settling, so there weren't any decisions on that. But that was kind of how we addressed the reasonable royalty issue. And in the different circuits, the laws can be different. In Georgia, we found a case that said there wasn't any evidence of licensing required. And then in the Ninth Circuit, we found some cases that cited a Third Circuit case, Kia Corp. And basically what that discusses is normally people use the reasonable royalty in like the hotel context. So it's like a franchisee keeps the name up, doesn't pay, and keeps using it. And you look back to see what happened before the contract was over, or whatever caused the breach or the termination of the license. And that's how you can kind of come up with a reasonable royalty.
Just very briefly, I wanted to point out that another form of relief is corrective advertising. The idea here is that there is an investment that the plaintiff needs to make them whole by allowing them to recover the cost of advertising. In order to do so is the relief that they would receive. And we've put some notes here for you to read at another time. All right, so now let's get to some fun stuff. Why does Romag matter, or does it even matter? You know, as an economist and you working with your damages experts, the reason it matters in this instance is because, as I mentioned, estimating plaintiff's actual damages due to trademark infringement can be difficult, or it can be very costly to measure if you find that you need to do announce trend analysis or surveys or other things that can be costly, that your expert says to you, these are the things that need to get done in order to measure the damages. In those instances, what you may find is that the plaintiffs may seek defendants' profits as an alternative. What that means, of course, is increased demand for damages based on disgorgement. The other thing that we might see is that you may see a decline in the use of reasonable royalty because of the fact that finding actual plaintiff's lost profits was difficult, or it may just be a backup alternative. You might find that your experts want to provide two different analyses. They may provide reasonable royalty and a disgorgement of defendant's profits in the same report. I think that what this also it naturally could lead to is that you may expect defendants to demand more rigorous evidence from the plaintiff to carve out other influences besides the infringement when it comes to accounting for sale. Ryan, I think you and Jonah had some things you wanted to talk about with respect to Romag.
Right, so this is a map of the circuits and which circuits were ostensibly overturned by Romag. The ones in red are the 9th, 2nd, 8th, 10th, and DC and federal circuits. Obviously, the 2nd Circuit is the circuit directly at issue in the case. We're in the 9th Circuit, and as Leslie said, there was not, technically speaking, a prerequisite to show willfulness to get the defendant's profits. And the reason is, as Leslie said, if they're competitors, you can also get to the profits that way. So there's a question as to whether Romag really did change the law in a significant way in the 9th Circuit. And I'll show you an illustration of that when we look at a case that's been decided since Romag here in California. The case is Erhawk versus Ontel. This is a case actually decided this month, or the ruling was decided this month. Erhawk, from the top picture, you can see they are an established company that I had them switched. The Erhawk in the bottom is the established company who's the plaintiff. They have the same name, Erhawk. The plaintiff manufactured things like seat cushions, motorcycles, and the like. The defendant manufactured an air pump for tires. They both use the same word, Erhawk, as a trademark, and summary judgment was previously granted in the case in favor of defendant on the disgorgement of profits issue. So the plaintiff, which I think any plaintiff would rationally do this, decided to move for reconsideration based on an intervening change in the law, and that change being the Romag decision. The court found that the parties agree that there has been an intervening change in the relevant underlying law. Now, I wasn't involved in the case, but reading it, I thought, why did they make that concession? It didn't ultimately matter to the outcome, but if I was the defendant, I probably would have argued it was not a change, or tried to make the argument that it was not really a change, because the narrow issue that was on appeal to the Supreme Court, which was the prerequisite issue, already didn't apply in California. You could argue it was not a prerequisite because you can still get to the type of profit if the parties are competitors. Okay, next slide. The court denied the request for reconsideration, and the analysis is interesting because it looks a lot like the pre-Romag analysis. The court cited the tradition that the defendant's mental state is relevant, and the Supreme Court found it highly important. So the district court here was not going to ignore that. The court focused on two key pieces of evidence. The first being the defendant Ontel's mental state. And there was two really factors here. The other being the fact that they had gotten a trademark registration. So the first was relating to the mental state. Ontel responded to a cease and desist letter that was sent prior to the litigation, and they identified the differences between the products and the trade secrets. So in other words, the defendant got a letter, they responded to it by saying they disagree and that the plaintiff was wrong. The plaintiff did not respond and then went ahead and filed a lawsuit. Well, if you get an opinion of counsel or the like, which a response to a cease and desist letter was probably drafted by a lawyer, it probably went through some case law and analysis, and they probably had some objective belief or subjective belief even that they did not infringe. And the court found that that was a factor in this analysis because their mental state did not reflect a guilty party. It did not reflect an intentional act to infringe if they had arguments and they expressed those arguments and got no response. The second being that the Patent Office had approved a trademark registration for the defendant. So they filed a trademark registration for their own AirHawk, the pump, and they got that. And the reason they got it, I presume, was that they're different products in different fields. Of course, that's relevant to whether they're competitors. So AirHawk had sought disgorgement not necessarily to be made whole, but to prevent the defendant from retaining gains made possible by wrongdoing. So this goes back to the proxy point that Leslie mentioned. The proxy was intended to be a proxy for the plaintiff's damages, but that was not what they were arguing here. They were not arguing that Ontel's profit was a proxy for its trademark damages. They were just making the equitable argument that it was unfair for Ontel to keep the profits made possible by their wrongdoing. Now, of course, the law before Romag was that you have to be a competitor and there has to be a proxy. So that's essentially the same law that the court here applied under the rubric of the Romag decision, but they reached the same result with largely the same type of analysis, which is interesting. So what do we learn from this case? So for an accused infringer, definitely, you don't know this when you're accused of infringement, but it's important to file and obtain trademark applications because that's evidence from the trademark office that there's no confusion. This was definitely useful in the AirHawk case in the sense that the court saw that the trademark office had stamped approval on the use of AirHawk for a different product. Always timely respond to cease and desist letters. That one should be a no-brainer, but you'd be surprised how many clients just think that they can just go without a response. Minimize evidence of a trademark knowledge. Don't go out there and document the fact that you know and that you think there's infringement. And to the extent that those facts exist, try to keep them under privilege. And make the argument that Romag didn't change Ninth Circuit law and don't concede a willfulness point. For the trademark holder, if the issue comes up in a case, argue that it did change the law and you have all those arguments. And try to have the last word. In other words, you would respond to the cease and desist letter explaining why you disagree, give them a couple of days and then file the lawsuit so that there's no argument that you did not respond. Use a trademark monitoring service, and these services will keep an eye out for similar uses of a trademark, and they're very inexpensive to use. And then include a disgorgement theory, even if you don't have willfulness and you don't have the competitor relationship, because the law could be evolving in this area. Also use a reasonable royalty as a fallback position, because if you don't get your higher amount of disgorgement, you still need some evidence of damages, and the reasonable royalty is a good way to go. This is kind of a recap of whether the Ninth Circuit actually the law did change or did not. I think you could make arguments on either side depending on what is in the interest of your clients. Yeah, and as Jonah mentioned, the jury instruction, an instruction that willful infringement is a prerequisite to an award of defendant's profits may be an error in some circumstances, such as when plaintiff seeks the defendant's profit as a measure of plaintiff's own damage. It doesn't say only in that circumstance. So you may have even another argument that we don't see here on the face. And this was the jury instruction before Romag. Next slide. Okay, so Banjo Buddies was a kind of a microcosm of how we may expect to see a fallout from Romag from the Third Circuit in 2005. And the Third Circuit at the time had abandoned a bright line rule that required intent to infringe to obtain disgorgement. So this was the kind of bright line rule that the Supreme Court has overturned. They had a 6-factor test. I'll just go through those factors briefly. Whether defendant had intent to confuse or deceive, that's obviously the factor at issue, but also whether sales had been diverted, the adequacy of other remedies. Obviously, those other remedies would include, the reasonable royalty. Any unreasonable delay by plaintiff in asserting his rights. The public interest in making the misconduct unprofitable, and whether it is a case of palming off. So they adopted that 6-factor test in place of the bright line rule. And the data shows that did not lead to a flood of cases or a flood of awards. So if that is any indication, and if you look at the Erosion case, perhaps even though the Supreme Court has changed the rule, we will not see a huge difference in the way that courts interpret it, although I would expect a difference in the way these cases are litigated. Next slide.
I think that's our slide.
That's it.
So, Jonah, do you have any thoughts before we turn to questions? I see we've got a few in the Q&A.
I do not have anything to add right now. I think we should just go to the Q&A.
All right. So I'm going to read it out. So the first point was, so all net profit is by law attributed to the trademark use and not any market desirability or superiority of the product or service. This is the question. And then with it, the fossil bag, for example, has a market value, design, leather quality, separate from the Romag name on a class. But does Romag get all margin profit on the bag after apportioned cost? That's a great question. And this is exactly one of the points that I was making when I was talking about calculating the damages. The idea is you need to show the sales related to infringement. What you have pointed to is exactly where you end up with the battle of the experts. How much of the sale actually should count as infringement? And that it depends on every case and the circumstances of the particular case, and how we are able to show our work. And this was Michael, who brought that in for us, Michael Perleski, also followed up by saying, follow up on that, even the fossil name adds a measure to the profit margin on a bag. Yes, absolutely. So here's a legal question for you guys from Anthony Keats. He asked, this case involved counterfeiting by a non-U.S. contractor. Was Fossil liable vicariously or contributorily for the counterfeiting of the Hong Kong contractor? Do you guys know?
There was not, as far as I could tell, a vicarious or contributory infringement argument that had been raised that it at least got ruled on by a court. It may have been in the case in some ancillary way. But I think it's an argument that you definitely would want to make. Also, with regard to the previous question, which has disappeared. Okay. Oh, it's over in the answer.
Oh,
okay.
Here, I'll bring it back. Can you see it?
Yeah, I was just going to mention that the jury verdict, I didn't put this into the deck, but the jury actually found that 99% of the value of the fossil bag was not attributable to the fastener. So, I mean, that's some good lawyering on the defense side, because that is a small piece, as Michael is saying. That little tiny fastener, how many people go into a store saying, I gotta have it. I gotta have the Romag fastener. Or they see a bunch of bags and that's the distinction. It is probably a factor, but if you look at the overall, everything that you would look at, or a consumer that would look at on a bag, it's going to be maybe 1%. Maybe you could argue it's more, but that's what the jury had decided on that issue.
Mm-hmm. And that's certainly where surveys can come in handy. When you start asking consumers about their willingness to pay and what is it about the bag that gives them value, you're going to get answers that will help you in those circumstances. All right. So the next question, also from Anthony, was, what liability was there for Fossil's breach of contract with Romag? Were damages for breach of contract a factor in the case?
Again, it's sort of the similar as the vicarious and contributory liability question. It didn't show up in the opinions. Yeah. I suspect that the contract probably didn't say that Fossil had to go and inspect the factory in Hong Kong to make sure that they were authentic Romag fasteners, and delegated that issue to the contract manufacturer. Most likely the contract that was breached was the contract with the contract manufacturer in overseas. And they, since the case was in the US and that party probably doesn't have an office here, they probably weren't able to really advance that type of argument in the US, although you could certainly do it over in Hong Kong if you were litigating over there. But that's how I would suspect the argument played out. I did not see it in the opinions. It may have been somewhere in the pleadings. And by the way, one point on contract drafting is, if you are in the position of Romag, maybe you don't have a lot of bargaining power, but at least try to get in there a duty on the part of your purchaser to police and inspect and audit what is happening with sales. Obviously, Romag knew whether folks were buying or not. So in a sense, it's easier for Romag to figure it out, but at least from a liability perspective, put some liability over on the defendant as well.
Mm-hmm. Okay, so the next question from Charles Wake is overhead allocated in determining costs to deduct from gross sales? This gets to, can you identify the aspects of what you call overhead and whether they are directly related to sales? So there's going to be a lot of discussion amongst the experts about how to apportion the very specific kinds of costs that you have and which of those can be deducted. Cameron Fatahi, I'm sorry if I mispronounced your name, says, are you saying that districts and circuit courts, for example, the Ninth Circuit, are more likely to just pay lip service to the Supreme Court's Romag decision and continue to not to award defendants profits absent a showing of willfulness?
You want me to take that one?
You can start and then I can chime in. But
I wouldn't use those words, but I think that if the Earhart case is any indication, they're going to continue to require either some form of willful conduct or competitive, the proxy rule that they're competitors, just because it makes sense. And if you look at the logic, this was in the Federal Circuit opinion, they went through, why is it important? Like, what's the policy behind requiring that to begin with? The policy is that it's a windfall. I mean, the defendant's profits on a product can be a huge windfall for the plaintiff and really not deserved. And so to counterbalance that, there's this idea of willfulness, and maybe that it shouldn't be a bright line, but it doesn't mean that all cases in which there's a demand for the defendant's profits, they will get it. There still needs to be some gate to make sure that it's a just and fair result. And if that means paying lip service and continuing to deny those awards for either no willfulness or no proxy for the plaintiff's damages, I think they'll continue to do that, because that would be, now there is going to be probably creative lawyering to try to figure out how to get around this, but it's not going to be blindly following a opinion by the Supreme Court in this regard.
Yeah, I think it's going to open it up a little bit. That's kind of how I see it. It didn't get rid of any kind of bright line rule. They can't just say you didn't show willfulness, which is hard to prove a lot of times and hard to show. So I think it's going to give, attorneys, if they are creative, ways to go after those types of damages that was more difficult. I think that depending, on the facts of the case, I think that's going to be a big issue here, because the case that we talked about earlier, those products were very different, and in that sense, it didn't make any sense. It's just that it made sense that the judge didn't allow that to go on anymore, and didn't, and ruled the way the judge ruled. But you could think of other factors or other cases with products that are either direct competitors or something else, they're involved with each other, that it wouldn't make sense. But I think it's going to be a fact-dependent thing, and that's going to be a big part of it.
Another
and
point
I think
on
that's
that,
why.
Sorry, Leslie, go ahead.
Sure. And I think that's why Charles's questions are good ones, because whereas there used to be a belief that maybe going after disgorgement of defendants' profits was a no-go, now if it gets more weight, there's going to be much more attention paid by defendants to making sure they've really narrowed in and gotten all of the costs that are appropriate laid out.
Another significant difference that we didn't really focus on in the presentation is just the way cases are being pled. Now, assume that you are a defendant and you're advising your client who just got sued for trademark infringement, and there's this allegation or this request in there for the profits. You won't be able to knock that out as easily now on a motion to dismiss or a motion to strike, meaning that you're an in-house attorney or advising an in-house attorney. You have to factor that in now as a potential damages award, and that could impact your positions on settlement, on mediation, far before getting to a jury, which most cases never get that far to begin with. So it could have an impact still on the way cases are litigated and settled. Even if ultimately jury awards don't end up changing a whole lot, it's going to change the calculus of what is this case worth.
Okay, next question. So Charles had a follow-up, although I think that we've covered it, but it was the alternate side, what he asked, or must costs be directly related to the manufacture and or sale of the infringing product? I think that we've covered that. And then the next question from Jeff Tickhaven. Hi, Jeff. What changes do you foresee in trademark litigation overall in light of the current closings of retail stores and increases in online shopping and other circumstances changing in our COVID-19 time?
I'm from the school that the internet makes it a lot easier to find infringements. So I think that I don't think it's going to be that big of a factor whether there's retail stores or not retail stores, online shopping versus real world shopping. I think that it's a lot easier for the trademark people search firms to search for things that are infringing, and it's easier to find things because people are going to put everything online so that they can sell it. So I don't know, but that's kind of my thoughts.
I have 2 cents on that too. A lot is happening on Amazon, and Amazon now has a process where I have a client going through this at this moment. You can go to Amazon with a trademark registration, point out infringing products, and Amazon will take them down. And they do this as a way to avoid litigation against themselves, against their customers. It's pretty easy to get, and all of that happens without any litigation. And this is something that was not as simple as that prior to almost everything going online. So you could see it maybe decreasing litigation to the extent that transactions are easier online, and companies are also going out of business, and you may see their trademarks getting licensed. That could result in some litigation. But just in the past week, what Hertz has filed for bankruptcy, I saw Pier 1 filing for bankruptcy. You know, a lot is happening on the retail side, but you know, trademark law involves a whole lot more than retail. Fortunately, it involves anything online, really any business.
All right, we're getting close to the end here. We've got 2 more questions up, so I'm going to hold it at those. Tamara has another question. If there's not a real risk of having to give up at least a portion of your profits, wouldn't there not be a sufficient deterrent to someone who wants to infringe a trademark? Could it be said that sometimes injunctive relief may not be enough?
It's a great point. There needs to be something more than just a slap on the wrist and stop doing that, for sure. So I would answer that, yes, there is a real risk. I mean, there needs to be a real risk of giving up something in order for trademark law to have a deterrent effect. And I know just from advising clients that, you know, you get a cease and desist letter. Usually the main thing that the trademark owner wants, they just want it to stop. They're not out, the defendant is usually not out there trying to copy a trademark. Obviously this is different in cases of counterfeiting, but usually the injunctive aspect will resolve a case in my experience.
And I think that is one of the tougher parts about trademark litigation is the damages side. You know, a lot of the cases, it's not worth going for damages because they're just not there, and the injunction's enough to end the behavior that's affecting your brand, you know, your trademark. So I think, could this be a way to increase damages in trademark cases? I think so. I mean, I think that's what Ryan was kind of talking about earlier when he said that now you're going to have to factor in the fact that, you know, the profits, disgorgement of profits could be a possibility, and, you know, it could change some of the calculus, and it could, you know, increase damages potentially if there are profits.
Right. I mean, I think for sure, in cases where I make it clear to a plaintiff that it's very difficult or costly to estimate damages that are the plaintiff's actual damages, you can be sure they're going to go after defendant's profits now.
Because it's easier to identify. I mean, that's
right.
easy. You know, you just say, you get the numbers, and then you fight over what the costs are and what you can attribute. So then, and then it becomes a battle of the experts. So it gives you, and if there's a lot of profits, it gives you a lot to fight over if you can get there.
Exactly. Yeah. Okay. Tiffany Joda has the last question. In regards to trademark artwork owned by a company and the artist promotes his artistic services and posts the trademark artwork on a competitor platform, does the damages apply just to the artist who is posting the artwork or to the competitor as well, where the trademark image is posted? Or is there a defense to this use for promotion of work?
It seems like copyright may be more of a theory to assert in this fact scenario. But to the extent that the platform is using the trademark to promote some goods or services, I would think there's liability there. It just depends on the facts of what's happening. Normally, artwork is not used as a trademark, I don't believe, unless that artwork is incorporated into something like a logo. So I would look at this more from a copyright perspective, and in which case you'd be looking at the fair use factors as well.
All right, and the last comment from Charles Wake to Ryan is, you've all been great, but Hatch should have left his keyboard on the wall.
Okay, next time.
All right. Thank you, everyone. We really appreciate your participating with us today. We understand there are about 65 people registered, and this was super for us. please come join us at our IP, Internet, and New Media section meetings. We'd love to have you.
That's normally the last week of the month at 8:30 a.m. So get involved. It's a good committee.